And welcome to another JSTV snack, or
Tea
some
time.
tea time. We're going to talk a little bit about the one part of the civil claim against Karen Reed and the Waterfall Bar and McCarthy's Bar that was dismissed recently, and how that affects the whole overall case. The bottom line is not much, but it's interesting to get into. This is the negligent infliction of emotional distress claim that there was a motion to dismiss brought by the defendants as a group, saying that that's inappropriate because generally you got to either see, in this case, John O'Keefe being injured and dying, or you have to come upon it very quickly after it happened. And that Massachusetts, the law extends to beyond just the scene of the incident or the crime to the hospital room, apparently, right?
Apparently, unlike other states where you have to actually see the actual incident, like you're standing on the side of the road and you are a parent and you see your child get run over, and therefore you have an infliction of emotional distress. In Massachusetts, apparently, you just have to see the after effects come onto the hospital, come onto the scene after the effects, and that apparently gives you a negligent infliction or an intentional infliction of emotional distress claim in some circumstances. So,
yeah. So we've got the court's decision here, and I'm going to avoid giving people whiplash, I'm going to scroll to the part that is most important, and then I will bring that on the screen here. And remember, there are levels of emotional distress claims: intentional and negligent. Only the negligent has been granted, and only as it applies to niece Kaylee.
right.
So let me get to that particular spot. Okay. And then we can talk about what impact it has on the case as a whole. So this is sub E, claims asserted by Kaylee. The defendants argue that the complaint does not assert sufficient facts that Kaylee suffered emotional distress, and that does not describe which conduct applies to which claim. As discussed above, Kaylee's claim for negligent infliction of emotional distress must be dismissed for failure to state a viable claim. Okay, that's the bottom line. Sorry, I'm doing more scrolling than I had hoped. Where are you there? Oh, I see. I just zoom by here and I see Turtle Boy in quotes. Anyway, there's reckless infliction, right? Which is basically intentional. I'm not sure that any other states call
Grossly,
it reckless. Do they?
It's a grossness to it, and also reckless, intentional, negligent. We're just thrown in the kitchen sink. But you know what? In some way, that gets some possible insurance coverage.
Oh yeah, no doubt. And most folks know that homeowners insurance, this is where this kicks in. But if there are intentional acts only, your policy will not cover intentional acts. But they could cover negligent acts, and then they'll do what's called a reservation of rights letter. They'll send you a letter that says, we're going to provide an attorney and a defense. However, if it should turn out that you were culpable for something intentional, we're going to want our money back, and we're not going to cover you any longer. So they do that primarily because they don't want to be sued for what's called first-party bad faith. If you don't get coverage, and at some point it turns out you should have, then you're going to own the insurance company. They don't like that. The defendants argue that none of the plaintiffs have actionable claims for negligent infliction of emotional distress because their claims did not occur contemporaneously with the accident, giving rise to JJ's death. This argument is inconsistent, and they go on to case law, which you were so much a fan of, which says, no, maybe you just come upon it sooner rather than later, right? Thus, a family member is entitled to emotional distress damages when they either witness the decedent's actual injury or come upon the injured kin, is in brackets, promptly after the injury. That's the part that I think we agree is ridiculous. But that's what it is in Massachusetts. So in this case, they allege that Reed discovers JJ, and I think it's interesting that now we're calling him JJ. Never did, all through two trials.
I never heard of that before,
Yeah.
right?
But it is shorthand anyway. Discovers JJ buried in the snow, 6:03 a.m., subsequently pronounced dead at 7:50. And Margaret, John, and Paul each aver that they learned of JJ's admission to the hospital and then came upon his body at the hospital. Boom. So that's what this court believes is good enough. That's good enough. Against this backdrop, the complaint alleges sufficient facts that JJ's parents and brother arrived promptly at the hospital upon learning of JJ's death and thus have actionable claims for negligent infliction of emotional distress. However, Kaylee's negligent infliction of emotional distress claim, let me do this. Look at that, okay, stands on different footing. She alleges that she learned of JJ's death or injury when defendant Reed woke Kaylee up approximately 4:30 a.m. Further, Kaylee alleges she heard defendant Reed say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. Lastly, Kaylee states that as a result of Reed's conversations in her presence, she, quote, perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing event. Not good enough. Thank God they've drawn a line somewhere.
Boy, I tell you, some line. Everyone talks about how litigious everybody is and how there's all these causes of actions that get through courts, and then we see this.
Yeah,
it has nothing to do with the case. I'm not talking about the case. I'm just talking about all these different new causes of actions that allows pleadings.
And it expands, and what happens is they'll have a statute, and then these case laws continue to expand it and contract it and twist it and shove it around. Well, in this case, they've just opened it up, and now the line seems to be, okay, you didn't see the actual injury when it occurred, but you saw them in the hospital soon after. That's it. That's where the line is. If you just heard about everything on the phone, not going to count. Taken together, the complaint does not allege that Kaylee learned of JJ's death or injury at 4:30, but instead learned he was maybe injured at that time. There are also no averments regarding when and the circumstances under which she first observed the deceased JJ. Now, if they were able to plead, as I read this, if they had pled, not that she went to the hospital, because that clearly is something could be disproven. She didn't go to the hospital right away. But if at some point she saw his injuries, maybe, I don't know, if you take it to the absurd, at the funeral. I mean,
Right.
Somewhere along that line, that spectrum of injury to funeral, maybe she could have pled something actionable, but that didn't happen in this case. They didn't plead it. Who knows? Maybe they'll amend.
There's been a lawyer added from California to the plaintiff's attorney's team. So maybe they will. But right now, they didn't plead it. And the court, it was Judge Daniel O'Shea, just to add another judge into the mix of all the judges we talk about with all these cases. He's on the civil case. And he did allow Karen Reed's motion to dismiss the claim of negligent infliction of emotional distress, or they call NIED, as to Kaylee, that's John O'Keefe's niece, now known as JJ.
And we've reached out to Damon, whose last name I can't remember.
Seligson.
What's it again?
Seligson.
Yeah, and he did get back to us. We're still trying to kind of work that out. The law cited by
Reed's lawyer, by the way, just so people that understand.
Thank you. The law cited by the parties addresses scenarios whereby a family member has observed another family member actually being injured or otherwise suffering shock after promptly encountering the injured family member. Kaylee cannot make this showing. In making this assessment, the court acknowledges the following case law cited in the plaintiff's opposition. The determination. This is the law as it stands right now, and this is, if you're thinking about bringing a case, this would be the determining factor here. Let me see if I can do that. The determination whether there should be liability for the injury sustained depends on a number of factors, such as where, when, and how the injury to the third person entered into the consciousness of the claimant, and what degree was there a familial or a relationship between the claimant and third person. Now, this tells me, too, that if on that phone call, the 4:30 call, which was, I don't know where he is, maybe I hit him, what happened? But if it were a more definitive call, John is dead on the front lawn, I don't know what happened, that could have been enough.
If that's where we are in pleading civil cases these days, oh my goodness gracious, because I don't know. I'm a plaintiff's attorney, okay, but I've seen so many cases that have so many better facts on different on these type of counts. I'm not talking about whether this is ultimately going to be successful or not. I'm just talking about these amorphous counts where everyone puts into their complaint: negligent infliction of emotional distress, intentional infliction of emotional distress, reckless infliction of emotional distress. They all get thrown in, right? And courts usually throw them out for the most part.
Yeah.
because of the failure of intent, or because they don't want a case to get out of hand, or because they have wrongful death, or because they already have survival claims, or they have survival claims under 42 USC 1983, different things like that. So this is the first case I've seen where they're basically all allowed and suggesting that maybe if you amend your complaint, we're going to expand it
Yeah.
too.
And now that doesn't mean you're going to win the day, but in terms of civil cases where settlement is 99% of the time how it resolves, it has a huge impact.
Right.
Because insurance is now still on the hook in theory, and they might want to push their proceeds to the policy into the settlement pot, right?
Right.
So whether it's going to survive on the merits isn't always the only question. So in this case, but my follow-up scenario, that's that phone call would have been when it entered into the consciousness of the claimant. But because he wasn't dead then, it hadn't even been found at 4:30, the court said no good. That is where we're drawing the line. At least remember, the law is, as I say, a living, breathing thing. It could change. It could go back the other way. It could become more liberal. It could become more conservative. Who knows?
Yep. We're going to be following it at Justice Serve TV, and they have to be back in court when these
I
attorneys
believe that is the 25th of November. Let me double
21st, I
check.
think. 21st.
Let me double check. Let me double check. I thought it was the 25th. Oh, let's see. Wait. 25th.
25th. Okay. Why did I think it was?
Oh, wait a
before
minute. No, you're right.
No, it's the
I got two
21st.
of them back to back. 25th
Yeah.
is Fitzsimmons. 21st is
Is
at 2
Reed.
o'clock. I'll
Yep.
be there. I'm definitely going to be up for that interesting
And
adventure.
we'll be covering it here at Justice Serve TV. In the meantime, please hit that subscribe, like, share, and notify button, because we can only cover it if you cover us.
Hey, I like that. And try to do the right thing.